Today we're going to look at legislation in a bit more detail. Legislation can be divided into primary legislation and secondary legislation, or Acts of Parliament and secondary legislation, which is also known as delegated or subordinate legislation. An Act of Parliament is something that creates a new law, or it changes an existing law. An act starts off life as being a bill before Parliament, which is placed before Parliament, and it goes through a process which we will talk about in a minute. The bill must be approved by both the House of Commons and the House of Lords, and then before it can become law, it must be given royal assent by the monarch. Acts of Parliament make up what is known as statutory law in the UK. Now, I've done a link. I'm going to show you the link on that, where that quote above comes from, and that's guidance notes and definitions from Parliament itself. The second type of legislation is secondary legislation, or delegated legislation, or it's sometimes called subordinate legislation, and it often takes the form of a statutory instrument, or effectively an Act of Parliament is in existence, and that act gives powers for a minister to create secondary legislation, and it's these powers from primary legislation that are delegated to the minister to exercise by introducing a statutory instrument with, say, regulations setting out employment issues. Could be a number, hundreds and hundreds of different things. And again, you will see I've provided a link there so you can look at that definition again. This slide shows how a bill gets through Parliament to become an Act of Parliament. For example, on this part where it's in green, that represents the House of Commons. It's in green because the government, the House of Commons seats are in green, as the House of Lords seats are in red, so it's easier to see that way. Now, all bills start off with a first reading, and then if it gets through that, there's a second reading, and then there's a committee stage which closely scrutinises the act and makes advice on amendments, etc. Then there's the report stage, and then it's the third reading. The bill goes for approval to the House of Lords, which may amend and as they go through their process, and finally it comes out the other end and gets royal assent. That's a process. Now, a bill can start from the House of Lords, or it can start from the Commons, but it has to go through this process here and be approved by the House of Lords. So this is a guide to how a bill becomes an Act of Parliament. Delegated legislation. Now, delegated legislation is mainly through statutory instruments, and about 3,500 of them become law each year. So an awful lot of statutory instruments compared to primary legislation. The act that contains the power to make delegated legislation is often called the Parent Act, and it is usually specifies what needs to happen for the statutory instrument to become law. Many statutory instruments are not subject to any parliamentary procedure at all, and a minister can simply sign them into law. However, some are subject to a parliamentary procedure. Slide 5, again, that's parliamentary procedure with delegated legislation, statutory instruments, which are delegated legislation, that have to be formally presented to Parliament, are done through two main procedures: the negative procedure and the affirmative procedure. The negative procedure is basically it becomes law unless 40 or more objections are lodged by members of the Parliament, usually within 40 days. The affirmative procedure requires a vote, and it's debated at a delegated legislation committee, and it needs that process before it can become law. Let me help with that and assist with that. It's not a hard and fast rule, but most that have negative or affirmative procedures, most statutory instruments that have this usually have some important bits attached to the statutory instrument that will likely to affect a large number of people or be a considerable cost or financial cost to the government purse. And it's these things that trigger the negative and affirmative procedure. Two examples here. The first example, the Counter-Terrorism Act 2008. It says it's an act, so it's not a delegated legislation, it's primary legislation. And the other is delegated legislation, a statutory instrument, and it gives the number, and it's regarding civil aviation, and then it's got its name, the Air Navigation Restriction of Flying, Russian Aircraft Regulations 2022. So effectively, this is a very recent statutory instrument that has been used to stop Russian planes coming into our airspace. Apart from the procedural differences between primary and secondary legislation, and that primary legislation has to go through a full route in the House of Lords and the House of Commons and get royal approval, which is called assent. Secondary legislation is different to primary legislation in its power. Secondary legislation can be scrutinised and declared ultra vires, which is another word for invalid, by the judiciary through a judicial review process. So it's subject to being declared invalid through ultra vires process and judicial review. Primary legislation can't be declared invalid by a court of law. It requires amendment or repeal by Parliament itself to change it. We've talked about primary legislation, we've talked about delegated legislation, but we haven't talked about private acts of Parliament. These are primary legislation, but they may devolve power to local institutions, such as allowing for bylaws and things like that. So they still have to go through the legislation process fully, either in starting off in the Commons or the House of Lords. It proceeds in a similar manner to public legislation, but it is promoted by, it could well be promoted by an interest group from outside Parliament or a local authority who are keen on having this power for a particular purpose. So let's look at the definition. Private legislation is legislation which affects specific groups of people or localities under public legislation, unlike public legislation which affects all people equally. So it's more focused, it's specific. The persons affected by a bill that is likely to become private act of Parliament do have the right to petition against it and attempt to stop its progress through the Commons or the Lords, so that it has to pass through the Commons and the Lords to become law. I've shown a couple of examples here of private legislation. The Merseyside Tunnels Act 2004, that was about increasing tolls in the Mersey Tunnel. It was specific to 2 tunnels in Liverpool, and it didn't affect anywhere else. It just affected users of the toll tunnels going from Birkenhead and Wallasey into Liverpool. The Faversham Oyster Fishery Company Act 2017 is specific. You can tell by its name. It's about oyster fisheries, and it is not about anything else. And the final example, Nottingham City Council Act 2013, was an act to give Nottingham City Council the right to better control street trading in the city of Nottingham. In other words, to put restrictions up and make bylaws about street trading. So they're all specific to the locality or the area, and they are sponsored, if you like, by an interest group like a local authority, the Merseyside Tunnels, or the Faversham Oyster Fishery Company. They're sponsored by some outside body. Thanks for listening. We're going to be talking about international law as the final source of law that we're dealing with after the tea break and on the next piece. Speak to you soon. Hope this helps.